Good day, Crime Talk aficionados. Lori Vallow has been denied. Karen Reed wins a ruling. A Congresswoman wants to have child predators sentenced to death. A man pleads guilty to impregnating a disabled woman. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and you can check us out anytime on any of your favorite podcasting apps. Just a quick public service announcement. That's right. We will be going live tonight, 6 p.m. Mountain Time. With the holidays, it's been several weeks since we've done it, but we've got a lot to talk about. First, obviously, Luigi Mangione. We've got Brian Kohberger. We've got Karen Reed that we can discuss. And yes, we will also do the unboxing that we did last time. The new box has arrived, so we will unbox this tonight. I have no idea what's in it, but we'll wait and see. It's my battle box. This is not a paid promotion, but it comes every month, so I figured you guys might as well take a look at it when I do as well. All right, so let's go ahead and open the record for January 14th, 2025. And first on the docket is Lori Vallow. She was denied. Now, we brought you the hearing of Lori Vallow proceeding as her own attorney last week. Didn't go well for her. The judge seemed very skeptical, and one of the motions that Lori Vallow filed was that she wanted the state of Arizona, the prosecutors in the case, to produce discovery related to her extradition from the great state of Idaho. What does that have to do as it relates to the murder of her former husband and the attempted murder of her former niece's husband? Nothing. And that's what the judge ruled. The court's order is rather quick. In regards to the matter of Lori Daybell, she officially wants to be known as Daybell, but she's always going to be Vallow to me. All right, so we're going to keep it that way just to keep it consistent. All right, so the court has received the following motion. Defendant's motion to order the state of Arizona to produce discovery of extradition filed December 16th of 2024. The court has also reviewed the state's response to the motion to order the state of Arizona to produce a discovery in regards to the extradition filed January 5th of 2025. The court has also considered the arguments the defendant has placed on the record during the hearing on January 10th of 2025, and the defendant has failed to establish there is any relevance to the requested documents, nor that the disclosure of extradition documents would be reasonably likely to lead to any discoverable information related to the crime in which the defendant is charged. It is ordered denying the defendant's motion. Doesn't go well for Lori Vallow. Now, here's the interesting part. She's representing herself. I'm sure she thinks that there is some sort of big conspiracy to get her back to Arizona, and that's why she wanted to see it. She said in her hearing, when she was making her argument, that she understood that they weren't going to come get her, so why now did they come and get her? Well, it doesn't really matter. What does it prove? I mean, she'll get the bill for the cost of extradition that she'll never pay. So I'm not sure what that is about. It's not going to be some smoking gun. I mean, she's charged with the death of her husband, ex-husband, Charles Vallow, by her brother, conspiring with her brother, Alex Cox. I'm not sure what the extradition has to go to prove the elements of that offense, right? If it doesn't go to prove or disprove the element of the offense charged, it's not relevant. Now, sometimes you got to build the bridge to get to what is relevant, but Lori Vallow failed to do so. We will continue to follow that case because it's the case that just keeps on giving. Next, Karen Reed. She's doing a little bit better, probably because she has some competent attorneys. So Karen Reed and her attorneys won a battle to keep their expert witness testimony regarding dog bites in the upcoming retrial. Now, for those who don't know, Karen Reed is facing several charges, including second-degree murder in regards to the death of her now deceased boyfriend, former Boston police officer John O'Keefe. Now, O'Keefe was found dead in the snow following a night of drinking with Miss Reed and some friends back in January of 2022. And while prosecutors say Reed hit O'Keefe with her car and left him to die in the cold snow, Reed had argued that she is the victim of a wide-ranging conspiracy and cover-up. Now, Reed's first trial on the same charges ended with a mistrial back in July of 2024, and the jury did not reach a unanimous verdict on any of the charges, at least not that were reported to the court. Anyway, the hearing that took place in regards to this Daubert issue, that's why they call it a Daubert hearing, was a continuation of that hearing that took place last month. Now, the issue is whether the proposed expert meets the 5 foundational requirements for admission into court. So the hearing, which began on December 12th, was continued to today concerning a piece of expert testimony that prosecutors want to exclude from Reed's retrial, and that is the testimony of Dr. Marie Russell. During Reed's first trial, Russell opined that the scratches and cut on O'Keefe's arm were the result of a dog attack. But the prosecutor, he was a little more prepared than the prosecutors at original trial. He came out somewhat swinging on cross-examination of the good doctor, challenging her opinions, but her methods as well that she used to form those opinions. Now, the good doctor, Dr. Russell, had to concede that there is no standard model that she knew of by which to evaluate dog bites. And because there is no methodology, no standard, you have to rely almost virtually on your personal experience treating wounds. But the doctor fired back saying, no, you're mischaracterizing it. The good doctor says she's relying upon her personal experience plus what she's learned from these numerous articles that she has reviewed. Now, when the prosecutor asked the doctor, Dr. Russell, what evidence she had reviewed in this case, Dr. Russell revealed that she had never been to the crime scene and had not read all of the case reports. So the prosecutor then continued on cross-examination of the doctor, saying, well, when you were considering excluding a car accident as a cause of wounds, did you know from the reports that shards of broken taillight were littered in Mr. O'Keefe's sweater? Dr. Russell, I didn't know that fact. The prosecutor then asked, well, when was the first time that you learned of that fact? The doctor had to respond, well, right now. And when the prosecutor asked Dr. Russell if the new information changed her opinions, she was a clear no. It doesn't change my conclusions that those abrasions were caused by a dog bite. Now, Chloe, the dog who lived at the property where O'Keefe's body was found, was rehomed by its owners before the first trial. And on Tuesday, the prosecutor revealed that the prosecutors had tracked down Chloe and made molds of Chloe's jaw and paws for comparison. Now, Russell said she was aware of the molds, but didn't think that they would help from her opinions. And Dr. Russell previously worked as an emergency room physician and forensic pathologist, and she testified that she relied on aspects of her training from all three in determining that O'Keefe's injuries were the results of this dog attack. Russell conceded during cross-examination that she had not peer-reviewed her findings in the case, but explained further during redirect, I wouldn't even know who to send it to because I don't know anyone with such experience. So, the judge denied the prosecution's request to exclude the good doctor's testimony, finding that Dr. Russell is an expert on dog bite injuries. The judge also noted that Russell's opinion is somewhat inconsistent with the DNA evidence in the case. However, the court concluded that these issues go to the weight of Dr. Russell's testimony, not its admissibility, and can be addressed during cross-examination at trial. Now, the attorneys are scheduled to return to court for another Daubert hearing on January 31st. That hearing will challenge the defense testimony regarding digital evidence and as it relates to these searches that took place on the phone. So now the retrial is scheduled to begin on April 1st. We'll see if that gets pushed back again. Now, here's what the issue is as it relates to expert witnesses, all right? Expert witnesses are simply anybody with specialized training and knowledge. It is a very low bar to be an expert. And if you have some specialized training or knowledge, you have to be endorsed as an expert. The prosecution did a pretty good job at this hearing attacking Dr. Russell. However, just because she doesn't come across as particularly great at the motions hearing, she may hit it out of the park at the trial. But the point is, you got to let the evidence in, let the jury decide what weight to give Dr. Russell's testimony in light of all of the evidence. One of the instructions that will be given is that members of the jury, you have heard testimony from an expert witness. You may treat this expert as any other witness. You may believe some, part, all, or none of the expert's testimony, and you don't have to give it any special weight and treatment just simply because they are an expert. They can completely disregard it. But this prosecutor, and this is what I'm telling you, ladies and gentlemen, retrials are bad for the defense. I do not recall, other than a case where we had to try it, I think, 3 times, did anything ever go better the second time through. Because the defense throws out there what they have. Second time through, look what the prosecution is doing. They're fixing all the errors of their ways from the previous trial. They're attacking these expert witnesses because they've now had sufficient time to look into it. Heck, they've tracked down Chloe the dog, who's been rehomed, to make impressions of the dog's teeth to see whether it would be consistent with Mr. O'Keefe being attacked by a dog. It's going to be interesting. If I was a betting man, I don't know if we can bet on trials. I know you can bet on just about anything, but I think the odds are going up for the prosecution. And remember, they brought in basically a former prosecutor who's a defense attorney to come in and try this case because they kind of lost faith and confidence in the previous attorneys who didn't do such a great job. This guy, I don't know if it's his only case he's working on, but it seems like he is coming after Karen Reed. Next on the docket, that's right, a representative by the name of Anna Pauline Luna, she is a representative from the great state of Florida, is unveiling a new set of bills that could have child sexual predators facing the death penalty. Now, 2 of her 3 bills, all of which are being introduced in the 119th Congress, would require sentences of death or at least life imprisonment for those charged with a wide range of child-related crimes to children. A 3rd bill would require guilty verdicts of rape and sexual abuse against adults to carry a mandatory minimum sentence of 30 years to life in prison. And she also suggested that the death penalty aspect could have put some people off on an issue that otherwise could get wide bipartisan support. But she argued that the child predators simply cannot be rehabilitated and therefore we need to just get rid of them. She said, quote, "If you're going to continue to push forward in a moral society, then you need to ensure that people like this, that are predators, are taken off the streets permanently." I'm not sure where this is going. I can tell you, obviously, if this is a piece of legislation introduced in the House of Representatives, that would be federal law. Most federal law involves, as it relates to these type of allegations, usually people downloading inappropriate images or producing and or distributing inappropriate images of children. And those guidelines already come out to life in prison if they are quite ugly enough, to say the least. So I get adding the death penalty to it. I'm not sure that it'll make it through, but if it does, it's just one more crime that would require the death penalty. Now, we've talked about this before, whether you like the death penalty or not. Obviously, most people want a safe world to live in, and you shouldn't get a volume discount for committing more crime by just simply saying, okay, now you're going to go to prison for even longer, so to speak. You see that a lot of times in prison cases where somebody's in prison for murder and they will kill a correctional officer, and okay, what are they going to do? Send them to prison again for life? So as you will see, most of the people that were on death row as it related to the pardons by President Biden, a lot of them were people that were already in custody convicted of murder. I knew of one case where they killed a gentleman in the cell. They literally pulled out his innards and insides and just did various things to them. And some people say, and he got the death penalty. So all those people now had their sentences commuted to life without parole. It is a good negotiation tool. Whether you're for or against it, it should be something in the quiver of the prosecutors to try and negotiate a quick resolution to a case that otherwise could go on for years. Next, a caregiver pleads guilty for assaulting an incapacitated woman. That's right, a man accused of impregnating a disabled resident of a home for profoundly disabled people pled guilty today to aggravated criminal sexual assault. Isaiah Fields of Aurora, Illinois, and he could receive up to 30 years in prison when the Kane County Judge John Barasti sentences him in March. Now, according to the plea agreement, between August 1st of 2023 and September 5 of 2023, Fields assaulted a woman while working as her caregiver at the Mark Lund Hyde Center in unincorporated Geneva, also in the great state of Illinois. The victim was 42 years old, and she's lived there for 20 years, according to the prosecutors. And she has what is known as Rett, R-E-T-T syndrome, a neurological disorder that has made her unable to read, write, or talk, and because of this, she could not consent to the sexual activity. Well, the woman was discovered to be pregnant in April of 2024 and gave birth shortly thereafter. Now, police said that distended abdomen, one of the conditions of her disorder, masked the pregnancy for some time. Now, Mr. Fields worked at the Mark Lund area for about a month before he allegedly engaged in this conduct. He also pled guilty to criminal sexual abuse for a 2023 attack on a woman at a home in Aurora, Illinois. He touched the breasts of the woman while she was sleeping on a couch, according to the prosecutors, and he was sentenced to 1 year in prison on that case. Now, Mark Lund provides residential care and educational services to profoundly disabled children and adults, and besides the Hyde Center, it has facilities in Bloomingdale and Elgin, Illinois. Bad man. I don't even know what to say about that. I think I had something to say, but I don't know. Bad man. Next, this day in legal history, January 14th, 1639. That was the adoption of the Fundamental Orders of Connecticut. That's right, on January 14th, 1639, the first written governmental constitution in modern history was adopted in the colony of Connecticut. The Fundamental Orders represented the first time that a government was based upon a written constitution anywhere in the world. Now, along with the Mayflower Compact, the Fundamental Orders served as a basis for the United States Constitution some 150 years later, which in turn influenced the development of later constitutions throughout the world. Now, 326 years after Connecticut adopted the original Fundamental Orders, the modern Constitution of Connecticut was ratified. And then on this date, January 14th, 1963, George Wallace was inaugurated as the governor of Alabama. Now, like I said, he was sworn in, and he was declaring segregation now, segregation tomorrow, and segregation forever. Obviously, Wallace's pro-segregation stance epitomized resistance to desegregation, prompting federal intervention and legal challenges that advanced the civil rights legislation. Now, he also got shot as well, and thank goodness his policies have been abandoned. Not a good man either. This kind of a theme of the day is bad men. Well, let's talk about another bad man. A West Virginia man was arrested for directing traffic around an accident Sunday with a firearm that he wasn't supposed to be possessing. Aaron Minzer, our dumb criminal of the day. That's right, he was waving the firearm to direct drivers around a vehicle fire near an exit in near Bridgeport, West Virginia. Now, police said that Minzer was standing in the middle lane, waving the firearm around dangerously, pointing the muzzle towards the cars in traffic to direct them around the vehicle fire. Problem is that Mr. Minzer was convicted of a felony back in South Carolina in 2017. Yes, and that continues throughout the United States. It's not just the state in which you were convicted. Anyway, now Mr. Minzer has been charged with wanton endangerment involving a firearm and persons prohibited from possessing a firearm, and has since been released from jail. Anyway, Mr. Minzer, you are a dumb criminal of the day. If you are a felon, you cannot possess a firearm. Not now, not nowhere, forever. Unless you get pardoned, you can't possess a firearm. Now, I know some people are going to say, oh my gosh, how'd this guy get it? Well, apparently got it from somewhere, and I guess the law saying that a prohibited person possessing it Didn't do any good. Now did it? I don't know what to do. Anyway, he could also face federal charges, which would carry somewhere in the neighborhood of at least 5 years in prison. Just something to think about. If you are a felon, don't possess a firearm. All right, that's all we have for you today, ladies and gentlemen. Remember, please join us live tonight, 6 p.m. We got a lot to talk about. We've got Karen Reed, we have Brian Kohberger, and we have Luigi Mangione. And yes, of course, the unboxing of the Battle Box and also the Magic 8 Ball question of the day. Please join us 6 p.m. Mountain Time. And remember, the Constitution matters.